DC the boys, Alabama prisoner profiles. What's going on with y'all, man? Make sure y'all like, subscribe, share, comment on the video, donate to the little platform if you feeling generous. Hit that membership up and hit me up in one of the socials if you're trying to come on the show, right? I want to thank you guys real quick for your continued support of the platform. You know, I really enjoy this stuff. And y'all keep me going with the positive feedback, so shout out y'all, right? Now, the state is set to catch their third hat of 2024 at the time of filming this tomorrow with the execution of death row prisoner Kevin Gavin. Let's hop right into that right now. Alabama death row prisoner inmate Kevin Gavin has said in a court filing by his attorneys last month he didn't plan on any more appeals of his scheduled lethal injection execution Thursday for the 1998 unaliving of a man in Cherokee County. In the past few weeks, he has been fighting for his life in a handwritten motion to a judge. The judge dismissed that request last week, and on Tuesday afternoon, the Alabama Supreme Court justices issued an order denying Gavin's appeal that had been filed on Monday. Gavin, 64, was sentenced to death for the March 1998 unaliving of William Clayton Jr. in Cherokee County. He is scheduled to be executed July 18th, but the time frame could go into July 19th if there are delays. He is said to die by lethal injection at William C. Holman Correctional Facility in Atmore, which is the only prison in the state with an execution chamber and where most death row inmates are housed. Gavin's attorneys on June 14 filed a lawsuit asking the state not to perform an autopsy on his body, saying Gavin is a devout Muslim and that his religious practices that the human body is a sacred temple which must be kept whole. Alabama officials agreed not to conduct an autopsy and the lawsuit was formally dismissed. In that lawsuit, his attorney stated that Gavin, quote, does not anticipate any further appeals or requests for stays of his execution, unquote, and the autopsy argument is not an effort to block the execution. But on June 17th, Gavin filed a stay of execution motion without his attorney's knowledge to the Cherokee County Circuit Court. At the time, he also asked the court for an informa pauperis, a declaration status that allows poor people to have court filing fees waived, to be injured. Cherokee County Circuit Court Judge Jonathan C. Bell on July 10th ruled that Gavin had more than enough in his prison account to pay the filing fee and denied the request. God damn. The judge also dismissed Gavin's motion for relief from his conviction and death sentence. In his motion last week, Gavin argued a jurisdictional issue that jurors in his trial should not have been told about his previous out-of-state convictions. The slang came just a few months after Gavin had been released on parole from prison in the state of Illinois. An Alabama jury convicted Gavin and voted 10-2 to recommend he be sentenced to death. The judge followed the jury's recommendation and sentenced Gavin to death. Following his conviction, Gavin's appeals failed in state and federal court. The United States Supreme Court declined to review his case in 2005, 2017, and again in May 2023 based on various legal arguments. The facts of this case are as follows. A little after 6:30 p.m. on March 6, 1998, Clayton, a contract courier for Corporate Express Delivery Systems Incorporated, was shot and unalived while sitting in a Corporate Express van outside the Regions Bank in downtown Century. Clayton had finished his deliveries for the day and had stopped at Regions Bank to obtain money from an ATM in order to take his wife out to dinner. There were 4 eyewitnesses to the crime, 2 of whom possibly identified Gavin as the shooter. Ronald Baker and Richard Henry Jr. testified they were stopped at a traffic light near Regions, near the courthouse downtown in Century at the time of the shooting. According to Baker and Henry, they saw a man get out of a vehicle, walk to a van parked on the street, and shoot the driver of the van. Upon hearing the gunshots, Baker and Henry immediately fled the scene. Neither could identify the shooter. Larry Twilley testified he too was stopped at the traffic light by Regions Bank in downtown Century at the time of the shooting. Twilley testified while he was stopped at the light, he heard a loud noise, turned, and saw a man with a gun open the driver's side door of a van parked on the street and shoot the driver of the van twice. According to Twilley, The shooter then pushed the driver to the passenger side, got in the driver's seat, and drove away. Twilley testified when he first saw the shooter, he noticed something black and red around his head, but that after the shooter got in the van and drove away, the shooter no longer had anything on his head. At that point, Twilley said he noticed the shooter had very little hair. At trial, Twilley positively identified Gavin as the shooter. Dwayne Meeks, Gavin's cousin and an employee of the Illinois Department of Corrections, testified at approximately 6:30 p.m. on March 6, 1998, he and Gavin arrived in downtown Century. When stopped at the intersection near the courthouse and the Regions Bank, Meeks said Gavin got out of Meeks' vehicle and approached a van that was parked nearby. According to Meeks, he thought Gavin was going to ask the driver of the van for directions. However, when Meeks looked up, he saw the driver's side of the door of the van was open and Gavin was holding a gun. Meeks stated he watched as Gavin fired 2 shots at the driver of the van. According to Meeks, immediately after seeing Gavin pop the driver of the van, he fled the scene, and Gavin got in the van and followed him. Meeks testified that Gavin honked the horn of the van and flashed his lights in an attempt to get Meeks to stop. However, Meeks refused to stop because he said he was scared. Meeks stated he drove all the way back to Chattanooga and told his wife what had happened. He and his wife and child then checked out of the motel and drove back to Chicago. They're there visiting from Chicago. Meeks testified that when he arrived in Chicago, he immediately informed several of his friends who were in law enforcement about the shooting. As a result of his conversations with friends, Meeks said he realized the gun used by Gavin was probably the gun that had been issued to him by the Illinois Department of Corrections. Meeks said he checked his home and determined that his gun was in fact missing. According to Meeks, he kept the gun in a drawer at home and not seen the gun for approximately 2 weeks before the shooting. Hey, yo, how you go 2 weeks without seeing your pipe? Meeks testified, immediately reported the gun was missing to law enforcement. Meeks admitted he did not mention to law enforcement when he reported the gun missing that he believed the gun had been used in the shooting. After reporting the gun missing and discussing the shooting with several friends again, Meeks said he then contacted Alabama law enforcement to inform him of his knowledge of the shooting. On March 9, 1998, and again on April 6, 1998, Meeks was interviewed in Chicago by investigators from Alabama. After the interviews, Meeks said he was indicted for capital murder in connection with the murder of Clayton. That charge was subsequently dismissed. Probably for his testimony, right? Danny Smith, an investigator with the District Attorney's Office for the 9th Judicial Circuit, testified on the evening of March 6, 1998. He was returning from Century from Port Payne when he heard over the radio there had been a shooting and that both the shooter and the victim were traveling in a white van with lettering on the side. As he proceeded towards Century, investigator Smith said he saw a van matching the description given over the radio. He followed it. According to investigator Smith, the van was driving approximately 75 miles per hour and the driver was driving erratically. Investigator testified he was speaking on the radio with various law enforcement personnel regarding stopping the van when the van turned on its blinker and stopped on the side of the road. When he pulled in behind the van, investigator Smith said the van abruptly pulled back onto the road and sped away. Investigator Smith said that he continued pursuing the van and that after he turned on his emergency lights, the van stopped in the middle of the road near the intersection of Highways 68 and 48. Investigator Smith testified that when the van stopped, the driver got out of the vehicle, turned, fired a shot at him, ran in front of the van, turned and fired another shot at him, and then ran into the nearby woods. Investigator Smith testified the driver of the van was black and that he was wearing a maroon or wine-colored shirt, blue jeans, and some type of toboggan or other type of cap. At trial, Investigator Smith positively identified Gavin as the person who had gotten out of the van and shot at him. After Gavin fled into the woods, Investigator Smith said he went to the van and checked the victim. According to the investigator, the victim was still alive but barely, and he radioed for an ambulance. Investigator Smith also testified that within minutes of Gavin's fleeing into the woods, several police officers arrived at the intersection, and the wooded area into which Gavin had fled was encircled and sealed off so that, quote, no one could come out and cross the road without being seen. Members of several law enforcement agencies then conducted a search for Gavin. Tony Holliday, a dog handler for the Limestone Correctional Facility, arrived at the scene with his beagle. At that point, Holiday said he had an investigator, Smith, show him the exact spot he had stopped the pursuit so that the dog would not track Investigator Smith's trail from the roadway, but would track the trail of the person who had entered the woods. Holiday testified that he then carried his dog to that spot and put him down. Holiday said the dog immediately picked up a scent and tracked it into the woods to a creek. Holiday testified that he saw a man, whom he positively identified at trial as Gavin, standing in the creek under a bush, and that when Gavin saw him, he attempted to flee. Holiday stated he ordered Gavin to stop, but Gavin did not stop until Holiday fired a shot over Gavin's shoulder. Gavin was then handcuffed, and several law enforcement officers assisted in maneuvering Gavin out of the creek, up the embankment, and through the woods to the roadway. Kevin Ware, a deputy with the Cherokee County Sheriff's Department, testified he participated in the search for Gavin and that he was present as Gavin was brought out of the creek. Deputy Ware stated that he heard Gavin say, quote, "I hadn't shot anybody and I don't have a gun," unquote. The evidence indicated that from the time Gavin was discovered by Holiday to the time he made the statement in Deputy Ware's presence, no one had had any conversation with Gavin regarding the shooting or why he was being arrested. And so that's going to do it with the statement of facts. For his case, I got just a couple additional notes here that I felt were noteworthy mentioning about it, right? Gavin's mother is reported to have described the defendant's life as influenced by or subject to a combination of drugs and gang violence while living in a Chicago housing project. Now, that's probably true. And now on his criminal history out of Illinois, Chicago, right? The defendant was convicted of burglary in Cook County, Illinois on October 25th, 1979. The defendant was also convicted of murder in the Circuit Court of Cook County, Illinois on June 9th, 1982, and he was sentenced to 34 years in prison. The defendant was paroled on December 28th, 1997, and was still on parole at the time of the murder on March 16, 1998. So, bruh served 15 years in Illinois for a B, right? And then catches another hat down here, right? Wow. Well, one more point. At trial, Gavin's defense attorney attempted to implicate Meeks, his cousin, as the killer by a combination of the challenges to the forensic evidence coupled with his challenge of Meeks' credibility. The defendant emphasized the undisputed fact that Meeks drove the defendant to the scene of the crime and Meeks' pistol was the murder weapon. The evidence of the defendant's guilt is, however, overwhelming. And there y'all have it, man. Bro's gonna be executed tomorrow, absent some type of miracle, act of God, Buddha, Allah, somebody, right? Y'all let me know what y'all think about this in the comment section. This is a wild one right here. That's why I was like, oh yeah, he done down something, didn't hit at the folks. Like, I gotta bring y'all this case, right? Which has no bearing over the, the death penalty, right? The state shouldn't engage in the systematic taking of life and blah, blah, right? That's my position anyway. But yeah, man, I'll probably do a follow-up on this after he actually gets executed, absent any type of stay or something like that. So y'all be on the lookout for that. You know what I'm saying? Maybe they'll botch it or something like that. Who knows? Like, subscribe, share my little content, donate to the little platforms if you're feeling generous. Cop that membership. I'm finna go ahead and start, I know I keep saying that shit, but I'm gonna get y'all some out of the membership, right? The three of y'all that are still gang riding it out, right? Appreciate y'all, man. Hit me up to come on the show. DC the Boys, Alabama Prisoner Profiles.